BREGER and SCANLAN versus ROBSHAW Custom Homes. Yes, may proceed.
I have a quick question. In other cases before the 5th District Court of Appeal, I was informed that, as an appellant, that I could bring up issues on rebuttal that I didn't bring up in my original oral presentation. Is that permissible in this particular case?
If you don't argue the issue on your initial, then you can't bring it up on rebuttal.
Okay, okay.
Okay, you may proceed.
Your Honors, my name is James C. Hauser. I represent the 3 plaintiffs in this case, Mr. Scanlon, Mrs. Scanlon, and Ms. BREGER. For clarification purposes, I would like to use STACEY Scanlon. I don't mean to show her disrespect, but just to clarify. Is the court familiar with the facts in this case?
We are.
Okay, well, great. Your Honor, it's my position, my client's position, that this case must be reversed if any of the following 3 reasons are accurate. Number 1, the purported acceptance by ROBSHAW, which I believe is really a counteroffer, did not mirror the offer made by STACEY. Number 2, the 3 individuals who filed the lawsuit were not one plaintiff, but 3 separate plaintiffs. And 3, STACEY Scanlon did not have the legal or procedural authority to dismiss the other 2 plaintiffs, Ms. BREGER or Mr. Scanlon. The standard of review, Your Honor, I believe is de novo. The issue in this case is really simple. There's an offer. There's what I believe to be a counteroffer. You can read those 2 documents, and those documents, as a matter of law, are going to be able, you will be able to decide whether or not the trial court did or did not err. The opposing counsel has brought up the fact that there was a lack of transcript at the hearing on whether or not the offer of whether or not the 3 plaintiffs should have been dismissed based on the offer of judgment. There were no facts taken at that hearing. This is purely a legal issue. Was there an offer, and was the offer accepted, or was there a counteroffer? In describing whether or not a defendant actually accepted the offer, the 2nd District Court of Appeals stated in the case of Pena v. Fox, 198 Southern 3rd 61 at page 64, the words are what matter because they will control who will or will not be released. The writing itself is the evidence of what the parties meant or intended by signing it. The contracting party's intent is determined from within the 4 corners of the document and construed in accordance with the agreement's plain meaning.
Let's talk about the words. The proposal here indicated that Ms. Scanlon would dismiss her complaint.
Right.
Some of the Supreme Court cases that are cited, that provision says more in terms of dismissing plaintiff's claims versus her complaint. So how is
Well, the distinction is simple. It's not her. It's her portion of the complaint, but it's not her entire complaint. As I'll address a little bit later, she doesn't have the authority to dismiss Ms. BREGER's complaint. She doesn't have the authority to dismiss Mr. Scanlon's complaint. So I don't see that as a distinction. ROBSHAW's purported acceptance did not mirror STACEY's offer, and therefore was a counteroffer. There's no question in the case of Barr that STACEY made an offer solely on behalf of STACEY. In Pena v. Fox, the offer stated in part My clients will not accept nor will sign a release containing a hold harmless provision, nor will my clients release anyone's claim other than my client's claims. Now, in Pena, the defendant accepted that offer, but added the following. It added that its agents and employees would be dismissed as well. Now, this in no way prejudiced Ms. Pena. Nonetheless, the Second District Court of Appeals ruled because the purported acceptance did not exactly mirror the offer, there was no acceptance. And this is what they said at page 63. Florida law further requires that an acceptance of an offer must be absolute, unconditional, identical with the terms of the offer. That is, the acceptance must be a mirror image of the offer in all material respects, or else it would be considered a counteroffer, and cites the Fifth District Court of Appeals Trout v. Apicella case, applying mirror image rule to hold that the insurer's proposal release of all claims rejected the plaintiff's offer. In language directly on point to the case of Barr, the Pena court stated, Mr. Fox's proposed acceptance would release additional parties. Mr. Fox's agents and employees, which Ms. Pena's offered, would not. His acceptance did not mirror her offer. Now, this case is much stronger than the Pena case. In Pena, there was no prejudice to Ms. Pena. In this case, there's severe prejudice to Ms. BREGER and to Mr. SCANLAN because their case would be dismissed as well as STACEY SCANLAN's.
Counsel, I'm going to have you probably skip ahead a little in your notes. Can you address the issue of were these separate and distinct claims? Because it seemed like the trial court judge, really felt like they were undifferentiated claims, that they were all
It was the
mixed
same
together.
claim brought by three different plaintiffs. And I think the best way to say that, and I'll be getting into this in just a second, they didn't own the property or sign the contract as a unified one party. They signed it as three different parties. But the bottom line is, if Stacey says, you know, I want to buy a new car and I need $10,000, I'm willing to settle for $10,000, and her husband and Ms. BREGER say, no, we don't want you to, she still would have the authority to settle the case just on her behalf, and she would be able to get out of the case. I want to emphasize something. This is not a case where Stacey, Mr. SCANLAN, or Ms. BREGER were trying to play games. They each simultaneously made an offer of judgment, each for $10,000. If ROBSHAW wanted to get out of the case, it could have accepted all three offers, paid the $30,000, and we would not have been here today. The bottom line is in Pena, and there's a case from the 5th DCA, Montgomery v. English. If the acceptance does not mirror the offer, there's no acceptance. Number two, the party that is bound by the offer of judgment is the party making the offer and the party accepting the offer. In this particular case, there's no question that Stacey's offer was unique to herself and not to the other two plaintiffs. Now, the trial court cited the case of Portundo. I've got it, but I don't have the citation. The Portundo case. In that particular case, Mr. Portundo sued, and his corporation, PTI, sued multiple defendants, including Farm Stores, Inc. Farm Stores, Inc. served an individual offer at Mr. Portundo for $70,000, but the offer specifically stated it did not include PTI. And what was the reason for that? Well, the reason is simple. If it included PTI, the offer would have been defective, because if you make an offer to multiple parties, the offer will be defective because one party cannot accept without the consent of the other party. Now, after Mr. Portundo accepted the offer, Farm Stores argued that by accepting it, the case filed by PTI against Farm Stores must be dismissed as well. The trial court agreed. In reversing, the 3rd District Court of Appeals ruled, number one, that PTI's claims were distinct from Mr. Portundo's, but more importantly, it also said, further, the only parties bound by an offer of judgment are the parties who made the offer and the parties who accepted the offer, unless the liability of the remaining party is derivative or subsumed with the claim of other parties. The word liability connotes the defendant, not the plaintiff. And of course, in this particular case, Stacey was a plaintiff, as was Ms. Breger and Mr. Scanlon. This is in accord with Florida Rule of Civil Procedure 1.442, the offer of judgment rule, C4, which says, notwithstanding subsection 3, when a party is alleged to be solely, vicariously, constructively, derivatively, or technically liable, then you can make a single offer to both parties without any sort of differentiation. The subsumed argument doesn't apply or make sense when you consider it from the plaintiff's standpoint of view. I think the best example of what we're talking about is when a offer is subsumed or a party is subsumed is when you have vicarious liability. Defendant hits my car, it's owned by my co-counsel, Doug Stanford. You sue both myself and you sue both myself and Mr. Stanford because whatever rights or liabilities he has is subsumed within my own liability.
But even then, the Supreme Court has allowed proposals for settlement to be made to both parties.
Well, I'm not sure you'll have to give me the citation.
Nunez versus Allen.
Well, in that particular case.
Allen versus, I can't remember, I guess it's Allen versus Nunez or.
Okay. You can make a multiple offer to a single party. You cannot make a multiple offer to a single offer to multiple parties, because if you do so, that violates Florida Supreme Court case law, because the individual offeree will not be able to accept without without having to consult the other party. Finally, Stacey did not have the legal or procedural authority to dismiss Ms. Breger or Mr. Scanlon. As I said, if you look at the complaint, throughout the complaint, they're referred to as plaintiffs, not plaintiff. They're not a single party. They're multiple parties. They own the property as joint tenants with the right of survivorship. That means they each had an individual percentage portion of the land. A joint tenant with the right of survivorship does not have the authority to bind the other joint tenant. In a joint tenancy with right to survivorship, each person has only his or her separate share. If a creditor attempted to attach Ms. Breger's property, the most it could recover would be 50% of her share. I'm citing the case from the 5th District Court of Appeals, Exavagon, I'm sure I butchered the name, versus Sunny Gifts, Inc., where this court said at page 1076, if property is held as a joint tenancy with right of survivorship, a creditor of one of the co-owners may attach the joint tenant's portion of the property. Bottom line is, there's no legal authority for Stacey to be able to dismiss either Mr. Scanlon or Ms. Breger. Furthermore, there's no procedural rule that would allow it. Now, the two procedural rules that were cited do not apply to the case at bar. First, the voluntary dismissal rule, 1.420A. That rule only applies to the dismissal of an adverse party, not a co-party. Likewise, Rule 1.250, dropping a party may be dropped by an adverse party. You cannot drop a co-party without that co-party's consent. The ROBSHAW spent a great deal of time arguing the case of Miller versus U.S. Security. We have no cause to disagree with the decision. It has nothing to do with the case at bar. In summary, ROBSHAW did not accept Stacey's offer because it did not mirror Stacey's offer. Stacey only to dismiss her complaint, not Ms. Breger's or Mr. Scanlon's. ROBSHAW added a new term by requiring that Ms. Breger and Mr. Scanlon's complaint also be dismissed, which the court agreed with, but it's a new term, it's new parties. 2, the 3 individuals who filed suit were not one plaintiff, but 3 plaintiffs. There was no evidence to the contrary because they own the property as joint tenants with right of survivorship. 3, Ms. Scanlon does not have the legal or procedural authority to dismiss the other 2 plaintiffs, and there was no consent that she be able to do so. Again, I want to emphasize, there is no question that ROBSHAW knew that each of the three plaintiffs was seeking to settle the case because there were three separate offers of judgment. Thus, we're praying that this court will reverse the trial court's order, hold that because ROBSHAW did not accept Stacey's offer, Stacey's case and that of Ms. Breger and Mr. Scanlon be reinstated. We have also asked that appellate attorney's fees be conditionally awarded. You can't award them outright. And it's conditionally awarded if, in fact, we win below and we are able to enforce our offer of judgment. Thank you very much.
Thank you.
Good morning. I'm Mac McLeod on behalf of the appellee, ROBSHAW. I think we need to start out by clarifying a couple of things. First is this notion that there are three separate plaintiffs. There's three people named, but the amended complaint says, and I quote, Allison M. BREGER, Mark S. Scanlon, Stacey M. Scanlon, hereinafter collectively referred to as the plaintiffs. And then in the amended complaint, as aptly designated and ordered and found by Judge Traynor, every one of the entire cause of action is collectively brought.
What authority does Ms. Scanlon have to dismiss the claims of Mr. Scanlon and Ms. Breger? Is there any rule that authorizes it?
Judge, I can tell you that she indicated that she had the authority when she made the proposal for settlement.
Even if she indicates she has the authority, that doesn't mean that Mr. Scanlon and Ms. Breger agreed to that authority. So what's the basis of your claim that she had the authority to dismiss their claims? Is it under a rule or is it under something else?
First and foremost, nothing is alleged in the complaint as to the amended complaint or in their offers as to their respective authority. And I don't think it's incumbent upon ROBSHAW to make a determination in a
Well, the
proposal.
judge enforced at your request to dismiss the complaint. And so to dismiss the complaint of Ms. Breger and Mr. Scanlon against their desire, he had to have found that there was some authority by Ms. Scanlon to do that. So I'm asking you, what's the basis of that authority? Is it a rule or is it something else?
My presumption is that the judge determined that since that they were collectively brought and that they collectively made, and that offer indicated that she would dismiss it with prejudice, that she had the authority to do so. Insofar as me quoting a statute or a case saying one or the other, I will tell you—
If she thought she had the authority to do it, is that a basis? Or wouldn't there have to be a legal basis to take away the rights of Ms. Breger and Mr. Scanlon?
Yeah, there is remedy if that's the case, but the remedy is not against the offeree.
Well, let me ask you this, and here's what concerns me about your argument. Let me give you a hypothetical. Let's make Ms. Scanlon say she had 1% interest in the property. And let's say the damages, there's no dispute, are $100,000.
Sure.
But the question is just liability. Liability is going to be hotly contested. So Ms. Scanlon's there sitting, thinking, if this case goes our way, I probably benefit $1,000. If it doesn't go my way, I don't get any benefit. So I know, I've read Judge Traynor's opinion, his order. I'll make an offer of $10,000. I come out ahead if they accept it.
Sure.
And ROBSHAW says, hey, this is a pretty good deal. It's probably a 50-50 case, and I can get out for $10,000.
Sure.
And they accept it. So under your argument, the trial judge would have to enforce that situation.
Your Honor, under the
Even 1%.
Well, number one, no one knew about the percentages of ownership.
Right, but I'm saying under accepting your argument.
The answer is yes.
Okay.
I don't want to beat around the bush. The answer is yes. And the reason is because they made the offer. It's not ROBSHAW's.
They didn't make the offer. Ms. Scanlon made the offer.
She made the offer. And the other two plaintiffs have a remedy, if that's the case. And, there is a way to do this correctly according to Florida law. It's in the Duong case. And that is, you have one proposal for settlement, and it says that Jimmy ROBSHAW or ROBSHAW Construction will pay $30,000 apportioned as follows. That's exactly what Duong says.
Florida law also doesn't preclude individual plaintiffs from filing individual offers.
It does not. It does not. A
And
plaintiff just-
ROBSHAW received all three of these on the same day.
Sure. Well,
What made them pick this one?
Well, I guess because it was the first one. But to be perfectly candid. But at the same time, to both of these points, there is a way to do this, and they did it a different way. And what they said was, in a undifferentiated complaint with undifferentiated claims and undifferentiated damages, each said they would dismiss the complaint with prejudice.
They didn't
So
say the, they said, well, this one
her
says
or his, I agree. But as Judge Traynor said, his or her or whatever was the complaint. There's only one complaint, only one allegations of damages. And so, yes, the idea that this is some sort of gotcha thing, I would go to the Miller case. In Miller, what occurred there was, two cases were going on amongst the same parties.
Well, let me ask this, we're here on a motion, because of a motion to enforce. So
Correct.
your position is that, not that you said, okay, we will just dismiss her complaint, and the court dismissed her complaint. ROBSHAW's acceptance mentioned the plaintiff's complaint. It changed the terms of the original offer.
Well, actually, what the acceptance says is, attached here to is a draft amount of $10,000 payable to STACEY SCANLAN. This draft shall be placed in Ms. SCANLAN's attorney's trust account and not negotiated until the amended complaint brought jointly by plaintiffs against defendant ROBSHAW Customs Homes is dismissed with prejudice, and a copy of the dismissal is provided, which is pretty standard language in acceptance.
Does the acceptance referring to the amended complaint mirror the proposal of her amended complaint?
There is absolutely no difference. There is only one complaint. There are no separate claims or separate damages. They are collectively the plaintiff. And it is...
Well, then under that argument, even if it was an undifferentiated claim, you could do that.
No. The PTI case indicates that pretty clearly.
Yeah, but under your claim that it mirrors it.
I want the complaint dismissed in exchange for exactly what she offered. Give me $10,000, and I will dismiss my complaint.
Take a PI case with a loss of consortium claim. So that's differentiated, right?
Sure.
All right. And if one of the two does a proposal for settlement and said they will dismiss her complaint, and then the answer was, I accept the dismissal of the complaint, under your argument that her and the is a mirror, then it would apply in that case, wouldn't it?
Fundamental difference. In a PI case where you have a
Right, but your argument is that the mirrors her.
Sure, it's the only complaint. Absolutely. And
Well, in the loss of consortium claim, there's only one complaint.
That's correct, but it's a different cause of action, different set of
But
damages.
I'm going to your statement that it mirrors, the acceptance mirrors the proposal.
I believe it does.
So in the hypothetical I gave, and the person with the loss of consortium claim says that, I offered to dismiss my complaint, her complaint, in return for, this sum of money, and the acceptance says, okay, we'll pay you the money and we accept dismissal of the complaint, you're saying that's a mirror image.
Well, it may or may not be. I don't think it is. But in the circumstance, there's a difference. The individual, the husband or the wife claiming consortium has a separate action. It's a separate count alleging separate things and separate damages. None of that exists here whatsoever. And in the PTI case, the court, and subsequent cases to that, in the PTI case, the case goes, specifically says that you could do exactly that. That is, a plaintiff can bind other plaintiffs regarding subsumed or derivative claims. That's what the case law is in Florida.
Is it-
Now, it doesn't, however, release or serve to dismiss different damages or different causes of actions by plaintiffs in that case.
Does this say,
PTI case states that rule, but the holding of that case was not a factual situation where one plaintiff could dismiss other plaintiffs' claims.
Well, my understanding of the I'm going to call it PTI. It's a little easier to
what I call it,
address. And the Siegel case went with that, is that the plaintiffs with undifferentiated claims and requests for damages can dismiss the complaint on behalf of those whose claims are derivative or subsumed within theirs. The appellate ruling was that the plaintiff Portofino's acceptance of one defendant's offer did not bar plaintiff PTI's separate and distinct claims, although it did settle any undifferentiated claims, which is exactly what has occurred here. These claims are undifferentiated. And the Siegel case went on to...
what about the language in PTI that says an offer made by one party to another cannot bind other parties?
Well, it says the person, the proposal for the offer binds the offeree. That is, the parties to that are the offeree and the offerer. I understand that. But then they discussed whether or not the plaintiff can bind other plaintiffs with respect to the similar or exact claims. And they indicated you could. You couldn't bind differentiated claims or plaintiffs with different damages or different causes of action within the same complaint. We don't disagree with that at all. And again, the way to do this, the way to make it clear is what occurs in Duong. There is a way to do this. They didn't. But let me ask this. What if ROBSHAW accepts this, pays the $10,000, the court rules the other way? That is, no, I find it. What has ROBSHAW gained? Basically what they're saying is she was just going to be dropped as a party because she has no separate claim. That's not what their proposal says. He gains nothing by paying $10,000 given the fact that, and they admit this in their brief, that even if he would have paid the $10,000 and she would have left the case through, I guess, the procedural vehicle of dropping to drop a party, in that circumstance, ROBSHAW goes to trial and stands the consequence of having the full set of damages.
But ROBSHAW could have accepted all three and just seen it as that was the total of the settlement offer.
Well, certainly he could have seen that, but I've long since abandoned the exercise of trying to, after 30-some-odd years of doing this, of trying to understand what the other side means. And the Florida Supreme Court and every district court in the state of Florida says it's not what you meant, it's what you said. Williston, Corbin, and the Florida Supreme Court in Blackhawk all say the same thing. This is not, the formation of a binding agreement is not a, quote, meeting of the subjective intent or meeting of the subjective minds. It's a meeting of the terms, the objective terms.
And I think what they say is that the objective terms refer to a plaintiff as opposed to plaintiffs, which is mentioned in the complaint. And then the singular plaintiff's claims and the singular plaintiff's complaint. So how do you derive multiple plaintiffs from those objective terms?
I haven't derived multiple plaintiffs. I wanted SCANLAN to do exactly what she said she would do and dismiss her complaint with prejudice. If, in fact, the other two plaintiffs are injured or hurt by that, they have remedy. And if they didn't authorize the lawyer to do that or to do it in that way, contrary to Duong, I hate to say it, they have remedy. But ROBSHAW is not ever to be in a place where he has to subjectively try to understand what they're doing in the circumstance. He gets to...
I agree it's an objective test, but let me ask you this. Are you aware of any case where a party has bound, where one party to an offer of judgment has bound another party, someone else that was not a party to the offer of judgment?
Well, I think the PTI case suggests that to some extent.
Suggest it's possible.
Sure.
I mean, you could have a case with a trust and it binds the beneficiaries,
Right.
but I don't know about two parties to an action.
And rather than be, the political answer would be to dance, but no, Your Honor, I don't know of a specific case exactly like this. But it is crystal clear per Gorka and the other matters, and I agree with counsel on this, that a single plaintiff making a multiple offer or an offer to multiple defendants without giving each the independent opportunity to resolve their case is not allowed. This is a different set of circumstances.
I think the problem is the statute and the rule on proposals for settlement are really designed for the one-on-one scenario, and sometimes they don't work too well when there's multiple parties on either side.
And one of the more interesting developments in law in the last 20 years has been the interpretation of this. But I think what has become crystal clear is you are bound by the terms of what you say that you're going to do. If there is an independent opportunity to settle the case, the Florida Supreme Court says that should be honored.
Is Ms. Scanlon bound by what she said she would do, or is she bound by what she's legally authorized to do?
No, I think that in this circumstance, she's bound by what she said she can do and would do in the circumstance. The issue of whether or not she was...
Let's assume that she was not legally authorized to dismiss the complaint of the other two. So that, that's the purpose of my question.
Sure. Well, let me go to counsel's analogy. He talks about a car. If I co-own a car with someone else, co-own the car, like occurring, and I sell it to a third party for $10,000, and it turns out the other person didn't want to sell the car, that person's remedy is not against the person who paid the $10,000 and got the car. That person's remedy is against me for misrepresentation.
Wouldn't the
or
question
fraud.
be whether the first person had the legal authority to sell it?
If they sign the title as the owner, I don't know how. I don't think Mr. ROBSHAW or ROBSHAW Construction is required to go ask questions about what they meant. We get to rely on the plain meaning, per the Florida Supreme Court, of what the offer said. And she indicated that in exchange for $10,000, she would dismiss her complaint. We paid the $10,000. We asked that the complaint be dismissed. And she resisted. So in those circumstances, what's happening is they're saying, well, our offers were ambiguous. Well, ambiguity is found against the drafter, and they drafted these. And then they're saying that ROBSHAW should have known. Should have known what? He is sued collectively by the plaintiffs for one set of damages and collectively in 2 counts alleging the exact same things, and he's told by one of the plaintiffs, and as it turns out, 3 plaintiffs, but separately, I'll dismiss the complaint, my complaint, for $10,000. And he says, okay, I'll do that. And if anything, I think all counsels should have been able to rely on existing Florida law at the time. And Duong, as I recall, is either a 2014 or a 2011 case. There is a very specific way that you do this, and it happens all the time. In my real life, I'm a medical malpractice and PI lawyer, and I constantly am doing proposals and receiving proposals for settlement. We have to know this law. And there is law, and that was Duong on how to do it. So if anything, I should have been able to presume that they knew the law.
Well, there was also in existence at that time a 2016 Florida Supreme Court case indicating, and I'm thinking Anderson, that when a proposal clearly and consistently uses the singular plaintiff, that proposal is limited to that plaintiff even when there's multiple plaintiffs.
If the claims are not undifferentiated, that's correct. So if plaintiffs have different sets of damages and different claims, one plaintiff can't cause the dismissal of another plaintiff's claim. We're not disputing that whatsoever. But joint owners and collectively refer to themselves as plaintiffs in the case and then bring a single cause of action is what occurred here.
Is PTI the case that you rely on? Is there anything else that you rely on for that proposition?
Well, in addition to the PTI cases, the Siegel case, which is quoted in PTI, And in Siegel, it says, unless the liability of the remaining parties is derivative or subsumed within the claims of the other parties to the offer, it basically quotes the language in PTI that plaintiffs can cause the dismissal of claims with respect to other plaintiffs if those claims are the same, subsumed or derivative. And that is the case. And we rely on it. I've relied on it. In the Duong case, I'm assuming that they knew it at the time, and they're making this offer. What would have happened, and I see I only have, what would have happened if Mr. ROBSHAW rejects all of these, goes to trial, and a verdict occurs at $12,501, 125% plus of the judgment?
Would you have the argument that they filed those proposals for settlement in bad faith and moved to strike?
No, I don't. I'm not making that argument. They filed.
No, but would you have that? I agree that's a legitimate point. I mean, I understand your concern. It's a legitimate concern, but is the remedy a motion to strike rather than an enforcement of an agreement between two parties by enforcing against two people who are not parties to that?
Let me tell you what I think I would have heard in that circumstance. That offer says very plainly, for $10,000, I will dismiss my complaint.
Okay. Thank you.
Thank you.
Could I have 10 seconds?
You know, Mr. Hauser, at the end, your opposing counsel raised an issue which he raised in his brief, and you responded by, well, that's not before the court. But obviously, if we write an opinion, we might have to be concerned with that. I mean, how does, let's say that you know that the most you're going to get out of the case is $20,000. That's your best, your expert has said you got $20,000 of damages. And so you each do a proposal for settlement for 10 each. And then when things go well, you win 20. And then you seek, or maybe you only get 12 and a half, 13. And then you seek your attorney's fees. I mean, how do we deal with that situation if there's a suggestion that the plaintiffs are game playing?
Good question. But that's not the issue before the court today.
But if we write an opinion, we might have to be concerned about that.
Well, I would urge the court not to, because I don't think it's been fully briefed. I don't mean to be disrespectful. I think it's a fair statement to say the issue today is very simple. Did they accept the offer, or was it a counteroffer? What I can say to the court, I think it begs the question. We sent out 3 offers. It was a total of $30,000. That's the minimum I expect that my client said the case was worth. They could have accepted all 3 offers. We wouldn't have been here today. By the way, we hope you have to decide that issue, because we hope that we win below, and we hope that we win with sufficient amount of money that we'll be back up here debating whether or not the offer is or is not enforceable. I'd like to clear up some points. Factually, opposing counsel said it was assumed that she had the authority to bind Ms. BREGER and Mr. SCANLAN. The opposite is true. By sending out separate offers, it is clear that Mr. SCANLAN was not going to be bound by STACEY. Secondly, the Duong case has nothing to do with this. Yes, we could have made a single offer that had been apportioned $10,000 each for Ms. BREGER, $10,000 each for Mr. SCANLAN, $10,000 each by STACEY. But we can also, as Judge Sasso says, we also could have done it in single offers, and it would be the same result. So we weren't trying to play games. I have urged my clients never make a joint offer. There's too many problems that come down the road. So whether or not it's bad faith or not, that may be an issue for another day. The only issue in this case is whether or not their purported acceptance mirrored the offer. It didn't. It was a counteroffer. The court asked the following question, does the complaint equal her complaint? And the answer is no. By the way, the PTI case, I respectfully disagree, never specifically ruled whether one plaintiff's case could be subsumed in another plaintiff's case. I agree with Judge Evander. The offer of judgment statute and rule is designed for a single offer and a single offeree. That is why we did what we did. Let's see. I guess one last thing. Could Judge Traynor have ordered Mr. Scanlon and Ms. BREGER to dismiss their claims based on ROBSHAW's acceptance of STACEY's proposal? And the answer, I believe, is no. The sole issue today is whether the offer is enforceable, whether or not the acceptance is enforceable. It isn't. Number one, there was no, it did not mirror the offer. Number two, there is no authority that STACEY's offer could bind the other two plaintiffs. Finally, and I don't mean to be disrespectful when I say this, if you rule in our favor, I again wish to remind the court to conditionally award appellate attorney's fees, so that if we win below, we have another chance to get these fees if we have to come back to this court again. Thank you very much. Any other questions?
All right. Any other questions? All right, thank you both. Court will be in recess.